Thank you. So yeah, good morning everybody. It's really nice to meet you. I'm Charlotte Sloan. I'm a legal director. I head up the South East employment team here at Birketts. There's a team of 7 of us and we're based in the Sevenoaks office, and across our national offices there's a team of over 50, and we're across Chelmsford, Cambridge, London, Ipswich, Norwich, Bristol and Bristol. So all across the East and the South East. And I've got Josie with me. So Josie's a paralegal in the team currently. She's actually qualified into the team, but we haven't got her practicing certificate right now. So she's still a paralegal, but hopefully shortly a solicitor in the team. So we've noticed an absolute uptick in litigation. I don't know whether others who are employment solicitors on the call have also noticed the same. So we've seen a lot more pre-litigation and litigation happening for our clients. And we act for businesses and also individuals across the whole of the South East. And that includes those smaller businesses, family-owned businesses, to the much larger +1,000 employees or PLC businesses. And we're noticing across all of those, there's definitely more contentious issues coming up. And as a team, we are finding that this trend was happening across our offices, and we commissioned some research to look into the detail of what were the trends that are happening. So we're going to present to you some of the sort of findings of that research, which will hopefully be on the screen very shortly.
They'll be coming in just a minute.
So bear with us. But that sort of research we carried out was a national survey in collaboration with Opinion Matters, looking at tribunal claims over a 24-month period. And we focused on some particular sectors. So we looked at hospitality and leisure, the care sector, and also the manufacturing sector. And we also looked at other organisations that were not related to particular sectors across, but had larger numbers of employees, so with 1,000 employees or more. And we surveyed over 500 HR professionals in England and Wales, and 400 of those professionals from those larger organisations with plus 1,000 employees. So that's the sort of starting point for the research we carried out. The findings. So we go over to the findings, which again, hopefully you'll get up on the screen shortly as well.
Slides should be with you guys as well, so just let me know if you don't receive those. So we did a survey, and we commissioned a national survey to uncover the trends that we're seeing over the last 24 months. And we split that across 3 particular core sectors. So that was hospitality and leisure, care and manufacturing. And across that, we were surveying 300 HR directors and HR managers from each of the core sectors, plus 200 from others as well. So we had a really good range of people to survey from. And essentially the ultimate reason was that we wanted to see how employers can limit the risks and the costs associated with employment tribunal claims. And we can obviously only do that once we know the impact of the survey. So that was the why, how beforehand. And then going through to the actual results. So the survey revealed that on average in the previous 24 months, respondents spent 4.8 working weeks on employment tribunal claims. So it's about 10% of time that we're seeing HR professionals give to these employment tribunal claims. Almost half, so about 44.7% of those surveyed clocked up between 5 to 6 working weeks on them. So it is a significant amount of time. So that's obviously showing a big impact on HR professionals, and that's obviously potentially quite stressful to handle. It can obviously have that impact on staff morale in a negative way. And also then business reputation just to consider as well on top of that. So the idea is that we want to be taking active steps to mitigate as much of these claims coming your way as possible. And obviously we've got the Employment Rights Bill implications as well. So it's a good time to be considering how best to progress here.
I think one slide.
Sorry, yes, I've gone to slide 5 actually potentially. So you might want to just Survey results, there we are. Yeah, that's one. So you can see they're 3 to 4 working weeks. So it's a significant amount of time that's being spent. Thank you so much. Slide 6, moving forward, will be excellent. Great. So looking at the volume of claims, so the Employment Tribunal statistics from April 23 to March 24 have shown a 14% roughly increase in Employment Tribunal claims. And those surveys dealt with an average of about 40 claims in the last 24 months. So we're seeing a really high level of claims. And yeah, when we look across the regions as well, those based in Wales, out of interest, saw the most claims in the preceding 24 months, where we saw an average of 46 claims. So that's actually almost 1 every 2 weeks, which is fairly significant. And then respondents based in England reported an average of about 38 claims over the 24 months. So yeah, big increase of claims across the region. Just the next slide, thank you so much. So just to give you an idea of the most common claims brought, so this survey here, the statistics really show a wide range of claims brought, but the 2 ones that really stick out are unfair dismissals, sitting at around 25%, and disability discrimination sitting at around 24%, followed by wrongful dismissal at 17%, 2P at 17%, and holiday pay at about 16%.
And this kind of mirrors the kind of type of claims we're seeing in practice, and it'd be useful to hear from all of you as well as to what kind of claims you're seeing in practice. Elaine, I can see you've got your hand up. By all means, shout out any questions or comments you want to make.
It was just to say, these are the ones that are lodged. They're not the ones that are actually heard. These are the ones that people have lodged.
Yeah, this is just from this research we've commissioned. So it's looking at those 500 businesses that we've asked the HR professionals, tell us about the tribunal claims that you've had lodged. Yeah, exactly. It's those statistics.
Okay, so it's not that they've been standing in a tribunal as HR professionals having to be cross-examined. Sorry, I just wanted to just check that. Thank you. That's
I've also got
some of them have.
I'm sorry, I've just got a related question to what Elaine has just raised. And are these numbers also reflective of claims that have been raised but settled out of court before it's reached tribunal?
Yeah, we're going to come on to that. So there's more detail looking into those particulars, but this is just giving you the overall picture. So these are types of claims that they were dealing with. These are the broad statistics in terms of whether it was unfair dismissal, disability discrimination, or the rest of it. And a range, and increasingly more complex litigation where it was alleging lots of different claims. And again, that's what we are finding in practice. It's happening an awful lot, particularly with discrimination. We're finding all types of discrimination claims being more regularly brought, whereas previously perhaps it was just more limited to unfair dismissal claims. But yeah, we have got some more detailed looking into those, what claims are settled. So we'll come on to that in a minute.
And interestingly as well, unfair dismissal being a big percentage there, but often in practice we see claims running alongside unfair dismissal a lot. So we see things like whistleblowing, harassment, pregnancy, maternity related issues running alongside an unfair dismissal claim. So that's useful to note as well. Then yeah, looking at settlement and resolution, just on that next slide for me, thank you so much. Yeah, so while respondents reported that claimants were successful after a full hearing in over a quarter, so about 27% of employment tribunal claims, over 3/4, so about 76% there, reported an above 50% settlement rate. So that's good. So that's before a final hearing specifically. So when we're looking at the resolution aspect of it as well, in terms of dispute resolution, most of the time over the past 2 years, mediation has been the preferred option and has been the most frequently used method of concluding these issues and these cases. So that sits alongside settlement via ACAS as well, obviously, just once that tribunal process has started. So mediation has been really good in terms of resolving the disputes. And then going a little bit more specific onto the next slide, thank you. Just looking at last minute settlements, which actually happen more frequently, I think, than people might know. About a quarter, so 24% of respondents reported that ET claims received by their organisations were settled the day before the hearing was due to commence. But we also have similar numbers reported on the day of the hearing. So when a hearing is actually taking place, we're looking at about 22% of cases being settled on the day. And then during the actual hearing, we're looking at about 23% of claims settled. So we've obviously seen a widespread of claims brought against organisations. And in terms of the most common reason for settlement, the survey actually showed that this was witness credibility. So there are obviously various reasons for witness credibility being the reason for settlement. Sometimes you have witnesses who have obviously, through the passage of time, their memory has potentially gone a bit murky on matters, so they forget things, and then actually their credibility when they're on the stand, they might potentially undermine the case as it's gone through the process. And also you can have witnesses who might also be bringing their own claims against the organisation, and sometimes then you have a hostile witness. So as the process goes on, when you have a witness statement and you're reviewing actually what has taken place and what the witnesses have to say, that can actually usually be a big trigger for settlement. I don't know if you want to add any more on that.
I'll just chip in this. Yeah, I think these stats are quite interesting, I think, from my perspective. I don't find that many claims in practice settle the day of the hearing. I think when people have got to the day of the hearing, it normally proceeds, in my experience. I don't know if that reflects everyone's experience on the call here. That's slightly different to the research findings we carried out. Has anyone got any comments or thoughts on that?
Hi, so I was trying to put my hand up, I couldn't quite find the button.
Nice.
I found that really interesting actually about settling at that last minute, because I was thinking in terms of costs, costs are incurred by that point. So that's obviously not necessarily the consideration that people have at that point. So I was then thinking it's interesting that perhaps it's more to do with reputational damage, that employers just really don't want to have that finding against them, as maybe a factor that's part of it, as well as the witness credibility. But like you say, I think generally speaking, the matters I deal with will settle in advance of getting to that point. So I'm quite surprised by those numbers too.
That's definitely my experience as well, Natasha. And I think, but perhaps also another factor as to why there is perhaps those more last minute settlements, that people are prepared to go to tribunal. They want to have their day in the tribunal and have that decision heard. But because of the delay getting to tribunal, whether that's a factor resulting in those last minute settlements as well, where people actually, it's such a long passage of time when it comes to the crunch of actually needing to have these witnesses on the stand being cross-examined, whether businesses are more open to those last minute settlements because actually the commercial risk is just too great, and the reputational risk, like you say, as well.
I'm just curious to know if in your survey, what percentage of those businesses fell within the small business sector? And the reason for my question is, obviously, as you might know, we focus mainly on the small business sector. And we, interestingly, a bit like what Natasha was saying, we don't see the last minute settlements. And a part of that could, of course, also be because of the business model that we follow, where we have the legal, we also have the insurance, which steps in earlier. And the minute the matter goes to ACAS, or, we are looking at negotiations and we start talking about reaching a settlement nice and early. And of course, we make clients aware of the rising costs, the more and more lawyers are engaged, albeit that's all picked up by the insurers. But that's why I'm just trying to understand what proportion of your numbers has been reflective of a small business sector, because the way they kind of arrive at these decisions is slightly different, whether or not there is insurance cover, but they are always very conscious of costs.
Yeah, this research, Sandhya, was in respect of larger employers. So the particular sectors that we outlined, and also employers with over 1,000 employees. So you'd expect those to be larger employers. So it probably doesn't, it would probably align differently if you did that research based on those smaller businesses. And I think you're right, a lot of those will have that protection and that cover. Larger businesses as well, but I think perhaps more commercial reasons behind not necessarily aligning with the insurance cover. That's what, again, I find in practice, whilst they might have that cover, they might make decisions that don't align with that cover. And that might drive those kind of actually more inclined to kind of get to tribunal.
I'd be interested to hear from, I'm sorry, go on.
No, so it's a good point though. I think you'd get very different findings if you focused it in a different way.
Yeah, and I'd be interested to hear from my colleague Ross, actually, because when my experience as an HR professional, and you're absolutely right, when working for the bigger firms in London, and settlement is just by the by. It does happen, and like you say, it might happen very much on the day before the tribunal, but it's just a matter of business. It just happens almost whenever there is anything contentious. It's not so much like that with small businesses. Settlement doesn't just happen. They will still try and follow process until it reaches that stage. It's a very different approach I have found in my job.
Yeah, I would agree with that. I in my previous life before being a consultant have worked for a big company, and going to a tribunal was much more common, because well, there was certainly a stage where the company started getting a bit of a reputation for throwing money at problems. And so in order to put people off from doing that, they could take the hit with a massive, legal bill, to make a point in principle to send the message. But obviously defending a tribunal claim varies massively, but you're probably not looking anywhere south at or less than 20,000 in order, just in the legal fees themselves to defend a relatively straightforward case. And when you're working with a big company, that's a small proportion of a massive budget. But when you're working with a really small company, like Sandhya and I do, and most people on this call do, that is a massive cost. And so
it would break the business.
I have not, I would say 99% of all of the things that the claims that, that the stop off at ACAS on the way for early conciliation have all been resolved. So I would say 99%, because the minute you tell the company how much it might cost just to defend, if you can settle for less than 20 grand, you're winning, right? So I think the small business or SMEs the data would probably look quite different.
I would agree with Roz, and I think also from my own caseload of when claims do arise, yes, claims arise, as we all know, with the best of intentions, and we have settled almost, touch wood. I don't want this to be the day when things turn out to be different, but we have managed to settle without matters going to tribunal. So yeah, but this is really interesting to know that things are left until the day before.
Yeah, I mean, statistics are still showing that a lot of matters do settle. So it's not saying that a lot of them don't go down that route. But I think you're right, the proportions will be different if you compared those larger employers to those smaller employers. But we'll move on to the next bit of the slide, if that's okay. But yeah, interesting discussion. Thank you, everyone. Is it me now? So yeah, in terms of the successfulness of those claims, so the findings of this survey found that 27% of those tribunal claims that did make it all the way to tribunal were actually successful, which again, I think that's a relatively high statistic. And I think employers that, had that awareness, they may be more inclined to look at settlement earlier doors, or certainly look at how they can minimise those risks of claims being successful in terms of their processes and in terms of their training. So move on to the next slide. Yes, a bit more detail about what stage that claims settle. So we found different statistics applied where we're looking at the different sectors. So almost a quarter of employment tribunal claims received by the hospitality and leisure organisations, which had over 1,000 employees in the last 24 months, were settled after exchange of witness statements. And I think I often, again, find in practice, it's either once the defence is submitted, where people know what each side said, that tends to encourage settlement discussions. Or at that later stage, when you've really tested the credibility of the evidence and witness statements have been exchanged, that tends to lead to those more productive settlement discussions. And then you've got that very early stage, haven't you, where people actually, do they really want to commit to this? And that's often where you get the settlement discussions as well. In the care sector, it found that over 28% of employment tribunal claims with over 500 employees were settled during the hearing. So again, quite a high percentage in the care sector. And I guess there's regulatory reasons as well. Maybe in the care sector, there may be more need to sort of get to tribunal as opposed to and commercial pressures in terms of that regulation that deter people from settling at those earlier stages. And then last but not least, we found that 2/3 of employment tribunal claims in the manufacturing sector for organisations surveyed with over 1,000 employees settled in the final hearing in the last 24 months. Again, quite a high percentage there in the manufacturing sector. If we move on to the next one. By all means, any questions, just do shout out. But in the survey, we also looked at the types of grievances. So before you get to tribunal, what were the kind of grievance cases that those organisations that we surveyed were dealing with? And we found quite a wide range of grievance cases, but the highest types of cases they were dealing with were things to do with pay and benefits, stress, probably not a massive surprise to those of you on the call, and discrimination and workload kind of grievances. But actually, there's not a lot of different, and quite a high percentage across all those different categories. But those first four being the largest percentage of grievances that we were kind of seeing. And again, I think that largely reflects what I see in practice. I'm definitely seeing lots of very convoluted grievances being raised by employees more and more. Natasha, you're nodding along. You're getting that sort of lots of those very detailed grievances. Yeah. I think people are just more aware, aren't they? More prepared to sort of fight.
Well, and also what I've noticed, I don't know about anyone else, but a lot of AI generated grievances.
Yeah.
So that they're a lot lengthier, they're a lot more complex. There's sort of so many different angles being thrown into the mix. I've got a 28-page one that I'm dealing with at the moment that has 50 something attachments as evidence towards it. So yeah, really, really complex, more than they've ever been, I think.
Natasha,
I've seen that also.
Sorry, can I just jump in? It's a really interesting point Natasha has raised. In terms of when you say it's AI generated, did you run the grievance letter then through an AI app? I mean, like an AI?
No, I can just tell.
You can just tell.
Just the terminology, the way
tone.
It's, the format,
Yeah,
the tone.
okay.
It's really clear that it's an AI generated grievance. And actually, what I think it's done, possibly, I mean, I can understand the benefits in some respects for the individual that has used that to frame the discussion. But I think what it's done is actually complicated it far more than it needed to be. And it's quite a lot to work through. But yeah, it just was really clear when reading through it.
But maybe it's something, again, for all of us here to look at, that if you're starting to, because I interestingly haven't yet seen an AI generated grievance letter. I don't know whether Roz or anybody else in this forum has.
We have it. It's clear.
Oh, you have, Elaine?
Yeah, very much so.
Yeah.
And you can tell that it's AI. And exactly, I back up what Natasha says, it has made it much more complicated.
Yeah.
And also I find it definitely does encourage people to raise all sorts of things, like the system does, stand up for your rights type thing. You get that coming over.
And I wonder whether we should all be investing in an app that can suss that out as well, because the last thing you want is for somebody to turn around and say, well, I never used AI in this. It's entirely my own. How do you defend something like that, isn't it?
Well, I think you still have to deal with it, though, don't you? I think it doesn't make a difference in terms of you've still got a grievance that ultimately you have to respond to. But I absolutely agree with those comments as well. It does make it a lot harder for those employers having to look into what is the actual issue that they're raising here. How do we actually investigate this, and how do we respond to it? I've also seen it on claim forms in terms of their particulars of claim that they've used AI to create. Having done it on the grievance, they've kind of replicated the same thought process in the claim form, which again makes it quite tricky. Is it Rihanna who's got her hand up?
Yes. Yes, thank
Hi.
you. Hi. So we're looking at health in the workplace at the moment. This is something that clients are asking us about, and obviously we're looking at gathering information to kind of give them some advice. And obviously stress is the second, well, it's actually no, it's matching pay and benefits. So when a grievance comes through that's stress related, obviously stress can cover so many things. What would that typically look like? What's a stress related grievance? Is that to do with workload, or could it be anything related to stress?
It's quite commonly thrown in there, isn't it, as a bit of a key word that you just chuck in there, and then the employer has to deal with that problem. I think the key thing with stress is it's not always a disability, but it can amount to an underlying disability. So it may be something where you need to be alive to, is there a need to investigate this further, potentially get occupational health input on it. But if it's short-term stress, it typically is not going to tick those boxes of a disability. So that's quite fundamental, I guess, to find out. It's not to say that you still don't have to deal with it, because you know, if you've got employees that are feeling stressed, obviously as an employer you need to get to the bottom of that, make sure you're not at risk of an employment claim, but also potentially a PI claim. But I think you're right. If someone's just said stress, we need to find out, well, what is the cause of that stress? Is it related to work-related stress? Is it related to something outside of work that we can't necessarily do anything about? And how is it impacting them in their day job, and what do we need to change as the employer? Anyone else got any thoughts and comments on stress? Is anyone else seeing a lot of stress-related references and grievances and claims?
Again, the one thing I've come across is stress. It just gets thrown in. But what we find is the way I tend to approach it is stress is actually a symptom. It's not the cause, and that's right. And that's also why many times when you refer somebody to occupational health for anything else, besides stress as well that they might have mentioned, occupational health will usually come back saying the cause of the stress is X, Y, and Z. So it could be some workplace situation, harassment, we don't know, or it could be a domestic issue. But equally, one of the things that we tend to do is, because stress does come up quite a bit, is to try and be proactive and carry out your stress risk assessments for a job, and try and almost do it a bit like you do your harassment training now on an annual basis. Just carry out something like a stress risk assessment, because jobs change, jobs evolve, teams change, maybe on an annual basis, and that shows that you've at least taken reasonable steps to try and manage stress within the team.
Yeah. Okay, that's good to know, Sandhya. Thank you.
That's all right.
We move on to the next slide. Yeah, so this is in terms of the numbers of grievance cases that the respondents in this survey reported dealing with. So quite high numbers, so 35 grievance cases in the past 24 months, which I think is quite high on average. And over half, 56% of grievance cases lead into tribunal claims in the last 24 months. So where those grievances started as just a grievance that perhaps has got potential for the employer to resolve it, over half of them were continuing and leading to those tribunal matters. So I think that again just shows the importance of making sure you are properly engaging with those grievances, trying to minimise dispute, using things like mediation if that's available to the employer or they want to take that route. But just ultimately just tackling the problem and trying to find maybe a compromise that resolves the situation to avoid a potential tribunal claim. Go on to the next slide, please. And then we also looked at disciplinary cases leading to dismissal in the survey we carried out. Again, this statistics here to set out the most common type of disciplinary cases that led to dismissal, discrimination and dishonesty being the highest types of dismissal cases, but again, quite a wide range of reasons for dismissal that we found from the research. Go to the next slide. And what came out from the survey quite clearly was that HR professionals were identifying that actually there were needs with the line managers to make sure some of these issues that were cropping up in terms of grievances or matters that resulted in a tribunal claim, there was an underlying problem with the line managers' training and support they needed in handling those processes. Again, we find that in practice. We carry out lots of training for line managers, just to help them understand, you know, what they need to do if there's an issue, to help them understand when there might be an issue that they need to flag to HR. And quite often, obviously, those line managers, they may be very good in their day jobs, but they haven't been trained as to how to deal with people issues. So I definitely find that in practice, that it came out very clearly from the research that there was a need there to do more and get line managers the training. And I think that's also going to be something that's going to be needed even more as we get the changes with the Employment Rights Bill, because there's just so much for employers, but also line managers have to understand, and they're only going to get that from that good training. Yeah, that was pretty much it, the conclusion of our sort of research findings. We have got some reports we can share that would be of interest, but has anyone got any questions or any other thoughts that they've got on what we've discussed?
Jordan, we haven't heard from you. Would love to hear your insights.
I think going back to the AI point, I work with Elaine, by the way, so we're on the same issues. But it's interesting, a lot of the points that are dragged up by AI on the other side are often incorrect. So you've got that issue. I think AI sometimes acts as a bit of a echo chamber, and it's sort of inclined to agree with whatever you put into it. So if you put into it these issues you're facing with your employer that could be quite weak, it seems to try and almost promote your ideas into being quite strong, even when they're not. So it's dealing with facts that come up that are actually a result of AI hallucinations, we've noticed. So that's another issue.
Yeah, that's quite an interesting one, isn't it? I think that there's obviously some great things about AI, but I think it is sometimes creating more work for us, certainly as employment lawyers, but also as businesses.
It can be good. It can give you ideas quite quickly, but I think a lot of the time, I mean, I've run a few things through it before, and it's come up with things that are completely blatantly incorrect legally, that a layperson probably wouldn't pick up on and would just run with it, and then maybe bring an ET claim that's completely unfounded because ChatGPT told them it was a good idea.
On that point, I guess I also am finding in practice that I'm increasingly putting in those strikeout requests as part of a defending a claim, which actually wasn't always the common thing you had to put in there, but I'm finding that is more common. I'm having to put that in to narrow down the issues where claims have been brought and are misunderstood in terms of how they've been brought. Also requesting things like deposit orders. And I think the tribunals, again, I'm finding in practice, they are certainly more willing to engage with those requests that you are submitting. Elaine, you're nodding as well. You finding that in practice?
Yes, it's a good idea to do that. I think it's a good tactic. But I haven't observed that the tribunal have picked those up and agreed with them as a result. But you know, tactically, it's a good idea to do it because it creates pressure on the other side.
Yeah. Any other questions or comments?
One of the things I was interested in was that the disciplinary on your stats just towards the end, where you said the most common reasons for dismissal, that that discrimination was virtually was at the top, I think. Yeah. So that means that there's more discrimination going on in the workplace, which it actually doesn't. Maybe it means that people are Googling and finding answers online when they're suffering discrimination. So it's interesting to see that it also means that employers are tackling acts of discrimination and finding, you know, the zero tolerance that they talk about in their employment staff handbook. It is actually something that they're following through on, and that's interesting. It's good.
Yeah, and I wonder things like the new duty to prevent sexual harassment of having an impact on that as well, and that's going to be extended, isn't it, more broadly? So whether they actually are being more proactive in that regard. I'm certainly seeing employers doing more training for staff on what that new duty means. So again, maybe line managers more prepared to call it out and deal with it, whereas in the past it may have gone relatively sort of under the radar and just not dealt with in that way, because of those ramifications of actually, if there is that somebody takes that matter further and they haven't dealt with it properly, it's going to result in further claims against them, essentially.
It'd be interesting to see what type of discrimination people are actually being dismissed for.
Yeah, I don't
What's
think it went
behind
into that all of that detail, but it's a good point. I think that would be interesting to kind of get that information and see how that changes as well as people tackle more with that new duty and as it gets extended.
I think this survey is excellent, by the way. I'm really interested in it. It was very good, the questions that you must have put to the survey company. So well done you. I think it's fascinating.
Oh, thank you. Yeah, and so we were finding in practice that we are seeing these trends, and we just wanted to cover a bit more about the detail. But yeah, I think it does present some interesting results, but there's lots more you could look into, certainly. So whenever you do a bit of research like this, there's always other angles you can look and find out a bit more. You have to say hello to Sarah Burke and Leon Deakin at night. I used to work with them.
Oh, did you?
In the Brighton office,
yeah. We're going to go down to Brighton and see them again soon. Yeah, I'll say hello to Sarah and Leon. Going back to this, the other what was it? I had another question. Yeah, so Jordan and I have had some difficulties with the online portal. Well, not exactly difficulties, but we're just finding it a nightmare. So I was just wondering what everyone else's experiences are and whether anyone's got any tips at all, but from either side.
I dislike the portal, Elaine, so I'm with that. I think having done the previous system and also one of those lawyers who likes to call and double check has it been received, and now that tribunal definitely don't like you to do that, do they? They just ignore your calls and you get abuse. I think if you try to call the tribunal, I think Josie had to go the other day to try and call and check something, and you didn't get a positive response, did you?
Yeah, actually, I think it's a bit hit and miss depending on who is actually receiving your call on the other end. I've had varying experiences, but so I think, especially if you want an answer about an update. I mean, I've been on the phone quite a lot, and I just keep ringing. The phone might go dead, and I'll just ring again, and I'll busy myself doing something else whilst I'm on the phone to them, and it's a bit of a nightmare. But after I think maybe three times, I did get through to someone. So it's really unfortunate, I think, as it is, because it makes things so difficult, especially if you're you've got a hearing coming up and you need to have a quick update so you can then update your clients, or you want to update your team. So tricky.
And maybe I think the idea, isn't it, obviously the information will be available through the portal a bit more online, but I'm not seeing that happening in reality at the moment. So whether in due course it changes.
I think it makes it more nerve-wracking as to whether things are being received. It shouldn't do. It should be the opposite. But actually, it does create more uncertainty. And that's what I just feel about it. So anyway, hopefully it'll evolve. It does say, doesn't it? On it, it says, please give us feedback. But I don't have time to do that. But I should at some point.
Yeah, it's a funny point we give the people, but I think they're just inundated on the tribunals. I think that's the crux of the problem. There's an increase in tribunal claims, the lack of resource to deal with them, hence the time it's taken to actually get to tribunal. We just have to work with the system that we've got. I have got another matter where actually a colleague's dealing with the tribunal matter. She's on holiday this week and something's come in and you have to log in through the portal in the right way. And that's just another layer of complication where actually you just want to see what have they sent quickly. You can't access it quite that easily. Sandhya, do you want to say something?
Yes, I just had a question, and this is going back to the very start of your presentation, where you stated that the whole reason you carried out the survey is just to try and sort of limit the risks and costs to employers and to mitigate even the onset of a claim. And of course, we've also spoken about how, what the benefits of training are and where, a good amount of training is currently being invested. Or where employers should be focusing. But I think for the benefit of members, I'm just thinking from this presentation, it would be helpful to touch upon really how does one go about yes, you can mitigate the risk of a claim, but what we are hearing more and more from employers, and I'm hearing this for sure, it'll be good to hear from everybody in the room as to what you're hearing from your clients. What employers are saying is it's just becoming more and more regulated for this, especially for the small business employer, where laws are passed more in keeping in mind the larger corporates and not so much bespoke for a smaller business sector. And we're finding that employers are finding that it's just getting more and more regulated. The more they do, the more contentious claims are arising. So, for example, we are seeing an uptick in claims where employees have been employed for well under even 6 months, and they will raise a discrimination claim. That's quite a common thing, theme that's arising. And processes have been followed, training has been offered. So, what else can an employer, regardless of size, do to try and mitigate these risks in
I think that's an interesting point, Sandhya, because I wonder, because people who bring in discrimination claims when they've got less than 6 months service, it's because they haven't got the requisite service, is it, for unfair dismissal claims at the moment. So whether that's going to change with what's coming with the Employment Rights Bill, whether they will start to bring actually an unfair, call it what it is, an unfair dismissal claim, rather than try to more tenuously link it to some kind of discrimination. I do think it's probably going to be the opposite, though. I think it's probably going to be people still bring the discrimination claims, and they also bring the unfair dismissal. Yeah, but that'd be interesting to see. I think it is the way it's going. It's obviously a lot more employee protection, and I think that's just a risk of employing people. So for all businesses, no matter what size, I think they're going to have that risk of people being litigious. But I guess to manage it and to try and mitigate against it, it's just making sure that they are aware of what protections are there, making sure that their policies and their procedures are as tight as possible. It's making sure that everybody is trained, so the line managers in particular are trained, who are making these decisions or implementing the action. I think that's all you can really do, so that if you then end up with a tribunal matter, which you might still end up, because obviously it's quite easy to bring a tribunal claim, it doesn't cost anything. There's a lot of awareness out there and publicity about it. But it's just about how, if you do get that tribunal claim hit, how you can kind of quickly resolve it, and that maybe that you can get things struck out, because actually if they're bringing it unfairly, maybe you do have a chance of kind of getting into the position where you say, well, that claim can't proceed. But yeah, it's tricky. I think it's tricky for bids at the moment.
Can I just add to that just a little point that I've noticed with obviously, and a lot it's come up very highly, discrimination, hasn't it, on a lot of the stats. And one of the things that my clients have finding, a lot of those, obviously there's many different types of discrimination, but a big focus is on disability discrimination linked to mental health issues. Lots of people being adults, sort of, I don't know how they phrase it, but the late diagnosis of things like ADHD,
autistic spectrum.
Yeah, I've noticed
neurodivergent individuals.
Neurodivergent, that's the one. So I've noticed a lot of issues around that, and I just wonder whether for employers, whether more attention is needed on those areas, and training and understanding of mental health issues might assist the overall picture of those sorts of claims coming through.
Yeah, I'm finding that in practice as well. Yeah, lots more sort of neurodiversity being raised, self-diagnosis of neurodiversity, and quite commonly not always raised early on. So perhaps when there's a disciplinary or performance issue being raised, it's at that point that suddenly gets mentioned, and obviously the statistics are showing there is more awareness of people having those diagnoses, and actually it needing to be considered. But whether some people are raising it in a way that is just disingenuous, yeah. But I think it's another challenge for employers. But I think you're right, awareness needs to be greater. And again, going back to line managers, I think also understanding, okay, where there may be some issue here that actually is causing these issues, just not just saying, well, there's a problem with performance, therefore managing it. What is the reason for those performance issues? Is there something that we can do? Is there some reasonable adjustments that we can make here? Need to be more considered. I'm also finding younger people who have those diagnoses, parents more inclined to get involved in the grievance and the tribunal claim. I don't know, again, a few nods on the call. other people are finding that as well. So it's not just the employee you're dealing with, it's the employee plus their parent plus the lawyers, because they ultimately will have the more financial power to sort of incur those legal costs. Sandhya.
Just to add to Natasha's point there, when individuals self-diagnose, you can just see employers completely getting, flustered and confused as to what to do. And I have to say, it is also, we are seeing a rise in that. And what we tend to do typically is, because it is self-diagnosed, but you've raised it in the capacity of an employee, we always refer the case to occupational health. And I know occupational health may well say, well, this person these are the symptoms, this is what they're showing, it's not been diagnosed. Considering it's been carrying on for more than 12 months, it may well be covered under the Equality Act. But at least what that does, we find, is it provides a structure and some kind of framework for the employer to figure out what they can do in relation to that individual's work in the workplace. Does that make sense? So that's the one thing I've fallen back on, or helped clients fall back on, because what else can one do when it's self-diagnosis?
Yeah. I think, ultimately being prepared to sort of test that evidence as well. Like if they got an occupational health advisor, just to kind of get some more information about it. But it's quite easy to get diagnosis, isn't it, as well, and pay to get proper diagnosis as well. But it's just that balance of actually, well, what does that actually mean in terms of what adjustments can we make? And it's obviously only reasonable adjustments the employer needs to make as well.
I think there's also another issue around those that can't afford to pay for a diagnosis, or an assessment and a diagnosis. It takes ages to get that through the National Health, from what I can hear. So self-diagnosis for a lot of people is all they've got, because they haven't been able to. So may well be completely genuine, but they just haven't been able to get a formal diagnosis from an NHS expert. And I think, just to adding on to what Sandhya was saying about going to occupational health, I think there's a series of questions that could probably be put to the employee about where the impact is, how what are the symptoms that you're experiencing, and how do you feel that impacts on your ability to do X, Y, and Z, because then that adds into the equation. And obviously you can do the OH assessment as well, but as a first port of call, is if they're just saying, oh, I'm neurodivergent and I can't do that, that's why there's a problem. Then you say, okay, well, let's look at that in more detail and say, what we can, because there is a preliminary conversation that you could have about what could we do to support you. And they may already know, so I'm just plugging in my laptop, they may already have some thoughts about what they need if they're not self-aware.
A good point, Ross. And I think actually you don't necessarily have to have that diagnosis either for you to have that knowledge of somebody having a disability that's covered by the Equality Act. So I think you're right that there needs to be that approach to things, and obviously if you do it that way, you may be able to resolve the issue so it doesn't actually explode into a bigger thing where you need to uncover a bit more about what's going on really, and what support do they actually need, and what do we as the employer need to do. I'm also finding, and I think my clients are finding this as well, is a lot of the time on occupational health assessments, they will push back that question as to whether somebody's got a disability to the employer. So does it tick those boxes in terms of a long-term adverse effect on their day-to-day activities? That's for you, employer, to make. But actually we'll tell you sort of what we've seen having met this patient, met this client.
Interesting. Yeah,
definitely. But I mean, from a point of view of an employee walking into their employment, they're really unlikely to want to tell, well, this is changing, but Until very recently, people have been incredibly wary of saying to their employer, actually, I have difficulties, I have got ADHD, blah, blah, blah. I do from time to time suffer from depression, I might need some time off. You know, that has been incredibly difficult to say. So then when something comes up later on in employment and they do suddenly say, actually, it's because of X, Y, Z, it does seem like it's because it's being raised at that stage for a reason, but it is often because the workplace hasn't been particularly open to people feeling like they can express that they have got some issues. So I think, you know, getting businesses to have more of an open door policy and talk about things, make sure that people feel they can raise it rather than feeling that they're going to be stigmatized if they do. But anyway, as I say, I think things are changing from a mental health point of view. People are being more open about their mental health these days, aren't they?
I think they are. And I think also I'm seeing increasingly businesses, and we do this as a law firm as well, share publicly, like, actually I've got dyslexia, for example, but I'm in this role and this is how I cope and I overcome those challenges which my dyslexia presents, and actually this is my superpower and how I use it. So that, I think I'm seeing that a lot more in practice as well. So I think that can have that real positive impact, that rather than people see, you know, raising it as an issue that actually they're experiencing problems in the workplace, they might find ways that they can use those role models and kind of actually use it as their superpower. There's not those issues where they're then being performance managed or whatever it might be.
I think on that there's also there's probably a difference between how and it's the same with any disability issue. Bigger companies are better placed to make the reasonable adjustments. The companies that I work with, and probably the same for a lot of people on the call, they're really small, and they don't have the budget to make some of the reasonable adjustments that someone might think is reasonable. And jobs can't be adapted quite so easily, because if you're the one marketing person and you've got to be able to do all of these things, and you can't do, or you're not so great at two of those things, you can't just, you could put support in place, but you can't change the job, because that would then mean that you had to employ somebody else, and they can't do that because they don't have the resources to do it. So I think there is a big difference between how big and small companies address that, and potentially the definition of a reasonable adjustment. Obviously the word reasonable is so vague, it's almost, you know, creates work for lots of, you know, people like me to work through it with clients, but you know, it is a factor. So you know, I think, you know, with that in mind, potentially if somebody's employment ends because of their performance issues and the job can't be adjusted, that then is going to mean that there's potential for more discrimination claims with those companies rather than the big ones. Do you know what I mean?
Yeah, that's a good point as well. And I think there's always that risk, I think, isn't there, of a claim, but it doesn't need it necessarily be successful, because of course in assessing that reasonableness of those adjustments being put into place, the size of the organisation should be taken into account, and the money that it's got to sort of make those adjustments absolutely should be considered. And I do frequently again advise clients that whilst we need to consider reasonable adjustments, if the adjustments they're asking for are beyond reasonable, it may be that we just can't do them, and actually we do need to get to a point of dismissal, because actually this is not possible. And yes, there is always that litigation risk, but you should be in a good position to defend that claim if it comes in. But yeah, it's that commercial choice, isn't it, as to how you approach things and whether you're prepared to take that risk. But I am definitely seeing people more prepared to raise those kind of claims and take things further. I had one example recently of a professional whose job, they had an allergy, which basically meant they could not do pretty much most aspects of their job. So it was going to make it very difficult to make any form of reasonable adjustment. And there wasn't any alternative roles for them. So I think in those circumstances, you have really got no other option but to get to that point of dismissal or compromise with some kind of settlement, both parties mutually parting ways.
And I think like the distinction that I think especially we've seen recently is helping employers think about like legitimate business interests as well, and like taking a step back from when, you know, those kind of claims can be really personal and can be quite messy, but actually taking a step back and thinking, okay, actually, have we got a legitimate business reason for you know, to not make X adjustment or Y adjustment or whatever it is. I mean, beyond that kind of reasonable kind of scope, it might just be kind of a helpful thing to think about in terms of, I don't know if it's reasonable or not, but is legitimately the business going to have impact in X, Y, and Z ways? And then that might be a bit more of a helpful mindset to think of when it comes to making those calls.
Yeah, there's also external resource that employers can use, isn't there? So there's smaller businesses, there are those charities out there that can help with things like equipment. So I think it's just thinking beyond a kind of narrow set of adjustments, trying to think as widely as possible, speaking to the employee as well, and trying to work out actually what can you actually achieve together to make this work. But yeah, you can absolutely draw that line at some point, because there will be a line. Rod, did you have another question?
Roz?
Yeah, sorry, I did have another question. I've completely forgotten it because I've reached that stage of life where I forget things instantly.
Sorry, I'm
on.
just conscious of time. Roz, why don't you email the question across to Beth, and then we can share it with everybody who's attended, you know, the roundtable, and you know, and we can just share it via email. Feel free to email it, because I'm just conscious of time, and it's probably the first time the roundtable has gone beyond 11:30, which is really interesting, and that just shows it's a really interesting sort of topic. And thank you so much, Charlotte, for having shared your survey results with us.
It's
Beth,
been a pleasure.
would you be circulating the slides as well amongst all the attendees?
Yeah, please do share the slides. It's absolutely fine. And any questions,
okay,
also
I'm
get in
sure
touch with us.
Yeah, and also because this session is recorded, we are going to also try and get it up on the Chamber website. The next roundtable is going to be on the 26th of November. I just want to thank absolutely all of you for attending these sessions, because it just keeps the conversation going, and we in fact continue talking about it even when we meet for networking. So please continue to sort of come along, and we are hoping to get another guest speaker. Beth and I are already working on it, actually, and we'll pop that on LinkedIn. Today's session, I'll just sort of do a post on it and tag everybody. So yeah, please feel to share, and also come along to the future ones. We'd be very happy to see you. All right. But thank you for your time.
Thanks, Sandhya. Thanks for organising it.
Thank you.
Yeah,
Thank
Thanks,
you.
thanks
so much.
guys at
Thank you.
Birketts.
Bye.
Thank
Bye.
you. Bye. Bye.
Thanks. Bye.